Hello and welcome to my channel. I'm Leanne Newton and today we're going to recap on what has once again turned out to be an eventful week in the Wayfarer and Blake Lively multiverse of lawsuits. I'm not a US attorney, I am qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I would appreciate it if you could please take a moment to like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. In the wake of last week's revelation about Vanzan and SubpoenaGate, there was a highly eventful week of legal filings, and I'm going to briefly recap on them. You can also go and check out my X threads that were written in real time. My username is KiaraJ2001. We've had some new additions to the docket. Wayfarer added a new lawyer from a third law firm. I was expecting Wayfarer and Jen Able to file oppositions to Stephanie Jones's motion to dismiss, but they changed course and filed amended complaints instead. Then Marvel entered the chat by filing a motion to quash the subpoena served on them by Wayfarer. Finally, we had noticed that Jed Wallace was going to amend his complaint against Blake Lively in the Texas case last week. That also came in and was a really interesting read. I'm also going to talk about the information surrounding the scope of the subpoena served on Stephanie Jones and look at what the New York rules of professional conduct say about this. There are a few non-legal bits of news I will be touching briefly upon as well, such as Blake Lively's Times 100 accolade and her controversial speech. And I will be talking about who I think should be nominated for a Most Influential Person of the Year award and why. So, Wayfarer have added a new lawyer, Mitra Ahirayan. She is a principal of the law firm Ahirayan Law, and she has been added to their legal arsenal. Ahirayan is a top California lawyer who specializes in entertainment law, particularly in the field of books and movies. She's not previously been part of the legal team against the Lively parties, and for good reason. She was at the premiere of It Ends With Us, and she celebrated in the basement with Wayfarer. This is Mitra Ahurian in the black dress, standing next to the lady in the red dress. She is likely to be a witness in the case because she was there and she saw what happened. Ahurian is also a long-time friend of Justin Baldoni's, so she is likely to be fired up at the shocking tactics that have taken place here. This is new, and for me, I find this quite exciting. It tells me that something is likely to be happening. What that could be, I don't yet know, but if I had to guess, I would say the most likely possibility would be, given her addition occurred in response to the news about Vanzan Inc., is that there could be an incoming lawsuit against Vanzan Inc. Now, we come back to the Vanzan subpoena again. I covered it last week, so I'm not going to go back over it in too much detail. But we do know some new information thanks to my honorary legal assistant, Ludwig the Sniffing Dog. He brought to my attention last week that there was a Deadline article in which Deadline had seen a copy of the subpoena and described what it was looking for. He noticed that the Deadline article mentions that the Vanzan subpoena requested all information from December 1st, 2022 onwards, highlighted in yellow here. This is the same subpoena request that Blake Lively had made of Wayfarer, which Judge Lyman had quashed for being too overly broad earlier this year. If you remember, Judge Lyman said that she could only conduct discovery from August 2024, as that is when, by Lively's own statements, the smear campaign is alleged to have begun. This is just speculation, but I believe that Lively requested that broad of a subpoena to cure how they had so much information from Stephanie Jones. I went back to the Deadline article and read firsthand the details it gives about the subpoena request, and then something else stood out to me. The article also confirms that the subpoena specifically referred to information collected from a cellular phone, highlighted in blue here. Now that is a highly specific request. It raises questions. How did Blake Lively know that there was information on a cell phone that referenced her and her family? How did she know that the information had already been collected from the phone? It is going to be very difficult for Lively or Jones to explain this, and I'd go as far as to say that I believe that it does support the allegation that Leslie Sloan called Melissa Nathan on the day the phone was confiscated and told her that she had seen the text messages and she should expect to be sued. Melissa Nathan, Brian Friedman, no one in the Wayfarer Party's team knew of this lawsuit or subpoena when they wrote their first amended complaint back in February. Their allegation regarding Leslie Sloan's call predates their knowledge of the subpoena scope. I think it's enough for a jury to believe that on the balance of probabilities, which is the standard here as this is a civil case, the scope of the subpoena shows that Leslie Sloan probably was shown those messages by Stephanie Jones and probably did make that call to Melissa Nathan. Otherwise, it is not bad foresight, given they apparently didn't even know the identities of the alleged defendants when they filed the Vanzan lawsuit. I would like to extend my thanks to Ludwig the Snipping Dog for sharing his find. It would be great if as many people as possible went and gave him a follow on X. I will put a link to his account, his X account, in the description. I will be doing educational posts on X, and in due course, when the Newton's Law segment of my channel is ready to go, I will also be doing educational short videos there with an animated and incredibly adorable feathery sidekick called Newton. That is going to be an exciting moment for me and for Eiko Ishiwata, who is very kindly designing all my logos, branding, and Newton's Law animation. She's amazing and so talented, and I'm eternally grateful to her for all her help. I will be coming back to Eiko later on, but right now I would like to introduce you to a still version of Newton whilst we talk about the law. He is so cute, isn't he? Now I want to look at some of the New York rules of professional conduct concerning subpoenas. We first explored these rules at the start of this lawsuit when Rule 3.6 became a talking point over Brian Friedman's statements to the media. I will be looking specifically at Rule 3.1. And Rule 3.2. Now, with our knowledge of the Vanzan case and its highly specific subpoena, which requested information collected from a cellular telephone, I decided to go back to these rules and dig a little deeper. I came across Rule 3.1, which governs non-meritorious claims. Section A in yellow says, a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous. The rule goes on to define what is meant by frivolous in Section B. The lawyer's conduct for the purposes of this rule, if, and then 3.1 in green states, the lawyer knowingly advances a claim or defense that is unwarranted under existing law, except that a lawyer may advance such a claim or defense if it can be supported by good faith argument for an extension, modification, or reversal of existing law. I am struggling to establish how the Lively's lawyers could have believed that this was a claim made in good faith and therefore was warranted under existing law. They should have asked the question of who was Vanzan Inc. and how were they related to the claim or the phone. Section B2 in pink states that the conduct has no reasonable purpose other than to delay or prolong the resolution of litigation in violation of Rule 3.2, or serves to merely harass or maliciously injure another, and this, for me, this section is useful for two reasons, in my opinion. Firstly, I think the lawsuit was used to delay and prolong in litigation. The reason I think this is because the Vanzan lawsuit remained open until the day before Blake Lively filed her CRD complaint. This bought time for Lively to use the improper discovery to build her lawsuit and give the New York Times ample time to go through the thousands of pages of documents, their words, that they claim to have. Lively essentially acquired an unfair advantage through improper means. Two, there is growing evidence that is leading me to believe that the intention of Lively's camp has always been to harass or maliciously injure the Wayfarer parties. The allegations which have been disproven, the taking over of the film, the underhanded tactics, and the mocking through a character in another film, and I know there are plenty of others, altogether, they leave me struggling to believe that anything has been done in good faith by Lively. Rule 3.1, subsection B3 in blue states, the lawyer knowingly asserts material factual statements that are false. This is where I think the strongest argument comes from. I've said in many posts and in my previous video that I believe that the substance of the claims in the Vanzan lawsuit mirrors the claims Stephanie Jones went on to subsequently make against Jen Abel. But the plaintiff was not Stephanie Jones, and Vanzan has no connection to the Wayfarer parties or Jones works. Therefore, the statements of the Vanzan lawsuit put forward to acquire the subpoena are false, and I can't believe that the Lively's lawyers would not have known that. I could have given them the benefit of the doubt that Lively could have lied to her lawyers, but the lawyers for both Lively and Jones have come out and doubled down, saying that everything that was done was legal, it was just a tactical tool. They've even accused Brian Friedman of faux outrage. So I don't accept the premise that the lawyers did not know what they were doing was wrong. I'm now going to get on my soapbox a little bit. The soapbox is what we British people call a rant. So one thing I would add is there have been some differences of opinion amongst the commentary lawyers on whether the use of a Doe lawsuit to obtain a subpoena that requires no notice was the stroke of legal genius or whether it was highly unethical. My personal opinion is there is nothing ethical about this, even if it is somehow within the rules. It may be the British part of me talking, but here in the UK, the right to privacy is every bit as valued and protected as the American right to free speech. We have strong data protection laws, and private information being sought in this manner without the data owners being made aware would not stand, and the evidence would have been thrown out already by now. I love a legal game of chess, and for me, this is not that. It is immoral. And if you have a perfectly good case that you truly believe in, you file the lawsuit and you go through the discovery process properly, like everyone else. I've already said that I believe the evidence supports that the information was shared weeks before the subpoena was served, and that is that this subpoena was only obtained to cure that fact. If the frivolous lawsuit was filed purely to obtain a subpoena, and I believe it was, then there is nothing ethical or legal about it either. If someone can instruct their lawyer to file a bit of paperwork and covertly obtain private, sensitive, and privileged information without you knowing, and whilst denying your right to lodge any objection, and the law supports that, then that is an absurd situation. It is not a great legal tactic, and the law needs to change. I would like to refer you as well to Cassidy O'Connell's amazing video on all of this, on other rules that I'm not going to talk about here, like the Civil Procedure Laws and Rules 3102. I will link her video in the description. She explains it beautifully and it's so easy to follow. I will also just echo a great point made by Not Actually Golden, which is that anyone who does actually think that this is okay and great lawyering, I challenge you, give your phone and the passwords for it to your worst enemy. And then let's see if you still think that it's not a problem. Now that I have got that off my chest, let's move on to the amended counterclaims from Able and Wayfarer. I'm not going to go into detail as most of it was the same as their original counterclaim. I'll just focus on a few specific paragraphs. There are several allegations throughout the filing by Brian Friedman that Lively, Reynolds, Sloan, and the New York Times colluded together, which, with all the mounting evidence, is getting harder to deny. As I've already said earlier, the subpoena request was so specific that it is hard to see how there wasn't prior collusion beforehand. One great point he does make is how could it have alleged a claim for a breach of contract while simultaneously claiming not to be able to identify the defendants? That does not make sense. Jones continued to access Jennifer Abel's data 5 months after confiscating the device. That is very clearly an abuse, and there are new causes of action specifically surrounding the breaches of the data handling and privacy. They include conversion, violations of the California Penal Code 502, violations of Federal Wiretap Act, violations of Stored Communications Act, and violations of Computer Fraud and Abuse Act. It is disturbing that Stephanie Jones had access to Jen Abel's iCloud for so long and could access just about anything and everything that was added to it. This included communications between her family, friends, and doctor. I have never shied away from talking about my own experiences. They are the reason why this movie was important to me, and I did experience something very similar with my former husband. For context, he is a technology expert. When the police forensically analysed my phone, they found nearly 70 monitoring apps on there that controlled everything and ranged from general tracking to being able to control my phone right down to the BIOS. He was able to send texts and emails which looked as if they had come from me. And he was able to access my banking information. He put a PIN-controlled lock on the device, so I couldn't do anything with it unless I entered the PIN, which obviously I was never given. And if I attempted to guess the PIN, the device took a picture of me and emailed it to him, so he knew I'd tried. In the end, he deleted everything, all of my photos of my family going back years, decades, including photos of my grandmother who had only died the week before. So I mean it wholeheartedly when I say I can imagine how Jen Abel must have felt when she found out that all her private information was being freely accessed without her knowledge or consent. Finally, I just want to address this point specifically about Jones potentially accessing communications between Abel and her attorneys for this case and Lively's lawsuit. Obviously, it doesn't need me to state how deeply personal communications are with friends, family, with your fiance, and your doctors. That goes without saying, and most people have these relationships, if not all people have these relationships. And they can imagine how horrifying it would be for that information to be accessed and shared by other people. Thankfully, not everyone has been in a situation of needing a lawyer or understands the magnitude of the privilege that is afforded to the attorney-client communications. In law school, you are taught that client confidentiality is given the utmost importance. Unless the client waives that confidentiality, the lawyer cannot disclose anything that is said between them. This is vital to help facilitate full and frank discussions between attorney and client, but also to protect any form of forced disclosure from opposing parties and their legal teams. There are very few exceptions to this rule, and breaching it without good faith can result in a barrister or solicitor being struck off in the UK or an attorney being disbarred in the US. In very serious cases, it could even result in criminal action. I cannot overstate the importance of this principle, and I don't think any lawyers would disagree with me. So you can imagine how deeply uncomfortable it sits with me that the opposing party in one case, who is also alleged to be a co-conspirator in another case, had access to those privileged communications, which likely would have included Wayfarer as a whole strategy planning because they were combined parties. Potentially, that could have included Jed Wallace's for several weeks. She had access to that. There was, at the time, widespread speculation that Lively brought her New York lawsuit to get ahead of a pending lawsuit. I feel like we may have just learned how Lively would have known that she was about to be sued. So as a result of Abel and Wayfarer both amending their complaints, the judge dismissed Judge Stephanie Jones's motions to dismiss against the counterclaims. This is not a win or lose situation. The amended complaints now supersede the original complaints. As a result, the motions to dismiss on the previous complaints are effectively rendered null and void. Stephanie Jones now has the choice to either file new motions to dismiss against the amended complaints or file an answer to them. Then we had something hit the docket that I did not see coming. Marvel filed a motion to quash the subpoena served on them by Wayfarer. And if the motion is denied, they are requesting a protective order to prohibit the disclosure of Marvel's confidential documents. This is a double-edged sword, as Ryan Reynolds has also been subpoenaed to produce documents about Nicepool, and Marvel is reminding the court that he is subject to a confidentiality agreement. If either of these requests fails, they seek to stay discovery until Ryan Reynolds' motion to dismiss has been decided. What they're effectively saying is, well, if you dismiss his claim, you don't need any documents from us. The subpoena is for information relating to the development of Nicepool and all communications that concern Baldoni. Marvel argues that Nicepool has nothing to do with the defamation and false light claims, but the information is being sought, at least in part, to show actual malice. I'd also dispute that to some degree, given that Reynolds has effectively affirmed Nicepool as being based on Baldoni and the SH claim references. If proven to be untrue, it could go towards false light, but that's just my interpretation. And an FYI, this is how you properly and ethically subpoena documents that are subject to a confidentiality agreement. You don't do it with frivolous lawsuits. I also want to point out that it is the height of ridiculousness that we have now had Marvel's letter asking for a protective order on any information concerning Deadpool and Wolverine. We've seen a letter from business partners of Blake Brown Beauty, and we had all the fuss a few months ago over attorneys' eyes only protective orders from the Lively et al. Camp. And now we're learning that they are happy to have unauthorized access to an individual's iCloud for months, file a sham lawsuit to obtain a covert subpoena without challenge or judicial oversight, and publicize someone's private medical information in one court, knowing it is under seal in another court. They want people to live by their rules when it serves their purpose, but they don't want to abide by those same rules themselves in the spirit of fairness. At the end of a dramatic week, Jed Wallace filed his amended complaint. So, heads up, Blake Lively's motion to dismiss will get denied for the same reasons as Stephanie Jones, and she will also get the right to either file a new motion to dismiss or answer the amended complaint. I'm going to get a little bit snarky here, because I'm genuinely angry at the underhanded tactics from the Lively's and Jones. We had almost a week's notice that this amended complaint was coming. Jed Wallace filed a notice that he was going to amend his complaint under Texas rules. I don't need to explain the definition of notice because I've been on my high horse about the lack of it in Subpoena Gate for the last 3 weeks. Also, just to highlight the difference between Wallace's first amended and Wayfarer's first amended back in February. Under New York rules, Wayfarer did not need to provide notice or seek leave to file their first amended. Jed Wallace did because of Civil Rule 15, which requires this under Texas law. When Wayfarer inevitably wants to file a second amended complaint, it will require leave from the court to do so. That involves filing the request with notice, to which the opposition gets to respond with all the reasons that they believe the judge should deny it, as if they have a leg to stand on at this point, and unless there is the likelihood that the opposition would be prejudiced, the court will almost always allow it under New York Civil Practice and Law Rules 3025B. Again, as I did with Abel's amended complaint, I'm not going to cover everything, and I've just picked out a few points that were interesting to me. One thing I did notice was that the filing made no mention of Vanzan or sham subpoenas. I've been asked why he would do that. In my opinion, it's not his argument. Wallace has put forward a much stronger argument in terms of the contradictory statements Lively has made. But his argument is essentially that Lively said in her California CRD that she had uncovered, and I'm quoting, the full extent of the smear campaign. But then she also made a sworn declaration for the Texas Rule 202 petition that she had no evidence and needed the pre-litigation deposition to find the evidence. These are two different statements, both made under penalty of perjury. It's a fantastic argument by his lawyer, because whether Lively has evidence or not is an issue of fact for the jury to determine. So I don't see her getting dismissed. That doesn't mean that Wallace's lawyer won't file motions, likely a motion to suppress the text messages because of how they were obtained. But the Vanzan lawsuit applied strongest to Abel because it was her data. So very briefly, because I did cover it earlier, Wallace's lawyer, who I admire every bit as much as I do Brian Friedman, is absolutely scathing about Lively leaking Wallace's confidential medical information in her filing. And he's right to be. That was just disgraceful. And as I said earlier, ironic given the mountains she has attempted to move to keep her own information hidden, along with information about her husband, businesses, and friends. Now on to a moment of positivity. Jed Wallace's new filing references the content creators' community's very own Colonel Kurtz. Colonel went to the premiere of Another Simple Favor in Texas a few months ago and carried out a protest. And I use the word protest in the absolute loosest way possible. She was the only person there protesting, and her banner was covered in rainbow colours and glitter. I'm sure I've read somewhere that Lauren Nidey said that Colonel Kurtz looked more like she was supposed to be at a pride march and had accidentally gotten lost. And I agree. I'm not sure what the reason is for including this moment in their complaint. There's no legal argument really being made here. If I had to speculate, I would think it may have been a nod to thank a fellow Texan for her public support, which would be amazing. Alternatively, it could have been a way to say to the judge, look, people don't like Lively. I'm going to quickly touch upon this. Firstly, the speech bothered me. I didn't like the way her allegations against Wayfarer were referenced for no other purpose than to say she wasn't going to talk about it, before immediately going into a story about her mother's experience with a co-worker. That felt like an attempt to symbolically connect two completely different scenarios in the minds of the people listening. I'm not going to comment on whether I believe her mother's story because I know nothing about it. It could well be a true story, and that's awful if that is the case. However, the timing of this being shared bothers me, as Lively has had 2 years to talk about this, or even just say, I know someone who's been affected by these issues, whilst promoting a movie about DV and SV. She never once said it. In fact, I've seen interviews where she's made contradictory statements. She answered questions about DV with sarcasm. And the other thing I felt about this speech and the way it was conducted was that I've seen similar comments made in interviews and, on stage by Colleen Hoover in many of her interviews about her own mother's experiences and, how those experiences inspired the book. But that is just my observation. But let's talk about this award for Time's Most Influential Person of the Year. Firstly, congratulations to Scarlett Johansson, who was also one of the winners. I have to be honest and say I don't understand why Blake Lively is being called one of the most influential people of this year, especially when you look at the reasons for the nomination. A donation she made to the NAACP Legal Defence Fund 6 years ago. She made that donation as an apology for being tone deaf enough to get married on a plantation. She also made that donation jointly with her husband, but he has not been deemed influential enough to justify awarding him with anything. That tells me that this is purely for damage control purposes. To me, being influential means being authoritative, being inspiring, being able to influence people. When Blake Lively first gave her story to the New York Times, and we all read those allegations, there were a huge number of people who believed her and turned against Justin Baldoni. Then the man who changed that public perception filed the first of the lawsuits against the New York Times, and we all saw how the text messages had been taken out of context or manipulated to give a misleading impression. Then the lawsuit against Blake Lively was filed, and point by point, each allegation was countered with evidence, and the public opinion largely did a complete pivot back in Baldoni's favour. That is the textbook definition of being influential, and for that reason, my nominee, my personal nominee, for most influential person of the year is Brian Friedman. The man has showcased great lawyering and really cares about his clients. He's continued working flat out on this case, even whilst losing his home in the California wildfires. He is my worthy winner. For next week, I'm hoping we may start getting some decisions on the pending motions to dismiss, as well as Marvel's motion to quash the subpoena. We may see some filings coming from the Wayfarer and Wallace camps regarding the Vanzan subpoena. Just because nothing has been filed does not mean no heated discussions are not going on behind the scenes between the lawyers. There absolutely are, and when they inevitably can't agree, they will start writing to the judge. Then we will see what is likely to happen. I mentioned my friend Eiko Ishiwata earlier. She is the powerhouse of talent who has been kind enough to help me with my brand designs, with Newton the Owl and these slides. She and her husband, Brett McDowell, have their own stories which tie into the pattern of behaviour we have seen from Ryan Reynolds. Ashley, Brianna, Eve and I worked together on the story of Dogpool and made the case for why we believed that the dog used for Dogpool was based on Brett's service dog, Starbuck. I will add a link to Ashley's channel and this video specifically. To add context, Brett was a cast member on Deadpool 2, and there are several personal connections to Ryan Reynolds, Rob McElhenney, and others in the circle. It also involves Mythic Quest and Free Guy. I will be doing thread series on their personal experiences, and I know they will have their own documentary on this coming out soon, which I'm incredibly excited for. I will also be doing some educational posts on X for the new causes of action against Stephanie Jones. And if I get some time in between, I plan to do some deep dives on specifically Jed Wallace and Liz Plank. Thank you if you made it to the end of this. Please do take a moment to like and subscribe to my channel, and I will post links to everyone I've mentioned in the description. Bye for now. Bye for now.